Hello and welcome. You are listening to Talking Trusts, a frankly speaking podcast brought to you by BDO South Africa. BDO has been providing professional audit, wealth advisory, and tax services to families and businesses for over 60 years in South Africa. And to be candid, we've seen a lot of trustees and families struggle with optimizing the family trust for wealth creation. A trust is a unique structure and certainly more complicated in its administration than managing a company. Talking Trusts is a series of conversations by trustees for trustees, where we unpack shared experiences and practical considerations to empower trustees with knowledge and confidence in executing their administrative responsibilities in the governance and compliance of trusts. I am Ricardo Teixeira, BDO Wealth Advisors Chief Operating Officer and your host for Talking Trusts. Thank you for joining the conversation. The Trust Deed and the Trust Property Control Act set out the functions that you need to adhere to in delivering on your fiduciary responsibility as a trustee. In essence, your responsibilities are centered around administering the trust deed and its assets for the sole benefit and in the best interest of its beneficiaries. In theory, this sounds easy enough to execute, right? In practice, though, what does it entail to be a trustee? How do you avoid the trap of that dominant trustee role? How do you ensure that all trustees play their part? And what happens when you make a mistake in the administration of trust assets? Today, we are joined by three experienced trustees where we talk about the practical considerations in administering a trust and its assets. Thea van der Spey is a chartered accountant, a registered fiduciary practitioner of South Africa, and a master tax practitioner. Through her company, Trust Protect, she accepts appointments as an independent trustee to a number of trusts in South Africa. Thea is also the author of Demystifying Trusts in South Africa, the definitive reference handbook for trusts, which now is in its second edition. Richard King is a chartered accountant who has more than 50 years professional auditing and accounting experience. He is an independent consultant offering advisory services in trust and estate tax planning, as well as administration. He consults widely on trust formation and the administration thereof. He is currently an independent trustee to several trusts, which includes family trusts, business trusts, non-profit trusts, as well as trading trusts. And Mark Stewart also joins us today. He is a previous CEO of BDO in South Africa, and he's currently Africa Markets Leader for BDO. In his 31 years as a partner, he has consulted to multi-generational clients in creating and administering trusts. He currently holds independent trusteeships on a number of trusts, including special trusts, family trusts, and testamentary trusts. Hello, Thea, Richard, and Mark. Thank you for joining the conversation. Let's talk trusts. The role of the trustee is central to the validity and existence of a trust. I'd like to get each of you to share what it really means to you to be a trustee. Mark, we'll start with you.
Hi, Ricardo. Thanks for inviting me to join you today. I think that the responsibility that goes with being a trustee is something that I always keep top of mind. You know, quite often I find that it's a real honor to be asked to become a trustee, particularly of a family trust, and that it's normally based on years of interactions with an individual or individuals, families. And I see it as an opportunity to really ensure that the next generation benefits from the success of those who have created the trust. And one should never take that lightly, because it is a big responsibility. But at the same time, because of the relationship that we generally have with those families, it's also a great honor to me.
Thank you, Mark. That's a lovely point. You're right, and is that honor, but with it comes the burden of responsibility. Richard, what does it mean to you?
Yeah, just to pick up from what Mark has said, both Mark and I are coming out of the professional accounting sphere. It's a service industry, and I see it as a service to my clients. Indeed, most of my trust engagements result from many years of being involved with those people, and I've been asked to either set up trust and or to administer trust, and it's a service to that client and a service to the next generation, and understanding very clearly the responsibility, as Mark has said. So for me, yeah, it is an honor, but it's serving my client.
Yeah, correct. And a very important service in terms of executing one the client's wishes and intentions. And Fia, your views in terms of being a trustee, I know we know what the academic and the Trust Property Control Act says, but how do you see it?
Together with the responsibility of being a trustee comes your fiduciary responsibility that you have to act in the best interest of the beneficiaries at all times. Right. We often see that because people have conflict of interest, they are the friends of the family, they are the accountant, the attorney of the family. Often we see that the interest of the beneficiaries kind of fall by the wayside. So I think if there's one thing trustees always have to remember is at all times you have to act in the best interest of the beneficiaries of the trust. And you have to be knowledgeable, which we will discuss later on. So a lot of people become trustees and do it very willy-nilly and not being informed at all in terms of what is required of a trustee.
Very well said. And if I reflect on what each of you have shared, I think that common theme there is the onus of the responsibility, that fiduciary responsibility. But it's quite important is that there will always be relationships, but how do you avoid that conflict? So I think very well positioned. If you just, I mean, I know the term lead trustee doesn't exist, and there's no such thing as a lead trustee, but it is often referenced, and we see it in practice, where we're dealing with the trust, and the trustee says, well, I'll be the lead trustee, or I am the lead trustee. Richard, I know you've had this experience where you land up being the lead trustee. How do you deal with this in practice?
Well, I think the first thing on this one is not to be too frightened of the term lead. It comes, of course, from being a lead independent director in terms of the requirements of the Companies Act. But a lead trustee is really somebody has to take responsibility and drive and manage the process, and that should be set up by the trustees in meeting. All trustees are responsible for all activities, and you can't have just one person going off at a tangent and doing his or her own thing. But somebody does take ownership in a manner of speaking, provided he or she reports back to his fellow trustees all the time and keeps them informed. In other words, a transparency. But you simply taking the lead in making sure that trust property is properly protected and actions are taken to look after that. If you do nothing, you'll all sit and wait for the next one. So somebody takes the lead. Now, what often happens in my case is because I do serve in some trusts that I was asked to join, but a lot of the trusts that I do serve on arise out of many years of service to a client. So I then look for other trustees and I bring them on board. So they look to me to take the lead in what we do. But I do that with their permission, and I ensure there's reporting back all the time. So there's no such thing as the lead managing director type trustee. Nonsense. Every trustee is responsible, but somebody does take control of the situation and make sure actions take place and decisions are made with your fellow trustees. But you're leading the show to make sure, indeed, that you are fulfilling your responsibilities and accountability to your trustees and to the beneficiaries of that trust.
Absolutely. Yeah. Thank you, Richard. I think very well positioned around sort of the reporting back and the communication. Mark, how do you deal with such situations in terms of mitigating that risk of being the lead?
Ricardo, firstly, to say that we must always bear in mind that each trustee has the same say in every decision. So while reference to a lead trustee is around, all trustees have the same input into decision making. But having said that, I really support Richard in what he's been saying, that in my view, the lead trustee is one who takes the initiative really in organizing the trust's administration, arranging meetings, distributing information. And in my experience, a lead trustee performing these tasks is really useful. Should there be a thought, though, that one trustee is more important than the others? Clearly, I'm not supportive of that, and I would object if I found myself to be in a position like that. But just confirming what Richard said, you really do need somebody in many instances to pick up the reins and run with it, because otherwise nothing will happen.
That's right, yeah, and I think you've both positioned quite well. It's that initiative to just, I think, practically look at how do you make sure that action is taken. So someone would take that initial step, but like you rightly said, everyone needs to participate. So, yeah,
Ricardo,
yes, Richard, yeah.
Could I just jump in there a little bit, just on something that's come to mind? The lead, as just been stated, is useful to take the initiative, make things happen, particularly where between meetings. Depending on the trust, some trusts you will have 2 meetings a year, 3 meetings a year. Some trusts you might have 12 meetings a year. Most trusts, I would imagine, 2 to 3 meetings a year. But in between those meetings, things have to take place. And very often that lead trustee makes sure those administrative type things do take place on a regular basis for reporting back at the respective meetings.
Right, excellent. So it's that momentum during the course of between meetings.
Yes.
Fiam, what's your view and your experience been in terms of avoiding that dominant trustee conundrum?
Ricardo, from experience, I want to draw a clear distinction between, let's call them the self-selected main trustee or representative trustee, who basically hasn't asked the rest of the trustees whether he could act in that role. We often jokingly refer to them as the executive trustee. And then obviously, as Richard and Mark alluded to, the fact that you need probably a person, a trustee who's going to drive the administration and the momentum on the trust. However, that should be selected by the board of trustees. Because we're sitting with a situation where we've got joint ownership of assets, there is not, the estate planner, as I generally refer to them, is not the owner anymore of the assets, because we say you need to relinquish control of your assets. So often in South Africa, people are having difficulty with that. So I think in inverted commas, we refer you to the main trustee or the dominant trustee being the person who's just self-selected.
Yeah, that's right. And I think so. It's that fine balance between you choosing yourself and domineering the decisions, as opposed to having that consensus by the collective. Yeah. It's Mark and Richard. Do you want to comment anything further on that, or should we just maybe move forward in terms of maybe some other challenges around the trustee relationship?
I'm okay with so far, thank you.
Yeah, thanks, Ricardo. I think we've got that covered.
Good. If we look at trustee meetings and trustee relationships, I mean, you've all indicated that it's the board, it's collective, and I think it's fair to say that it's not always going to be plain sailing. I guess there'll be times when relationships are tested, or even your credibility may be put to the test. I'd love to hear from each of you how you experience, or an experience where you've struggled in working with fellow trustees. And that could be, I think, a range of situations. But let's hear about some of the challenges that you've encountered. Mark, would you like to share first?
Yeah, Ricardo, thanks. And I guess when we get to talking about your fellow trustees, we can't underestimate how important it is that you do a proper assessment of the trustees that you're going to be working with.
Okay.
And I've had occasion where, for instance, I'm the independent trustee, and one has a married couple as the other 2 trustees. And sadly, when marriages come apart, that can often pose a real challenge. And not only is it a challenge in terms of the trust affairs, one needs to be really careful not to be drawn into some of the emotional challenges that the couple themselves are facing, which obviously then has a knock-on effect into the trust. So I think that one needs to be very cautious about that. And in fact, I seldom recommend that married couples, are two of the three trustees. If there are three trustees, if that is what is chosen, then my suggestion is to increase the number of trustees, so that one doesn't have a situation where you have two of the three trustees being antagonistic towards each other, acting in an emotional way rather than a rational way, which is just human nature. It's not wrong.
Yes, right.
But these are some of the challenges that I've experienced along the way, and if you can avoid them, I would suggest that you do some planning up front in order to do that.
And I like what you've shared, Mark. It's that twofold. It's like assessing who are you working with and understanding the competencies and the strengths. And I'm sure, Fia, you alluded to earlier about knowledge. And I like the practical perspective you share, is that often trusts are spouses or have spouses as trustees. And I guess it's quite an important conversation to have right up front in terms of challenging the appropriateness of it, Mark.
Yeah, Ricardo, absolutely. And I think Fia referred earlier on to whoever founded the trust realizing that they're no longer in charge of those assets. And there are occasions where one needs to remind the fellow trustee that they no longer have the same control over the assets, and that doesn't sit well with inexperienced trustees. Of course, those who've been around for some time realize that that is one of the fundamentals when you create a trust and pass over the assets, that you in fact lose control of those assets.
Absolutely. Fia, would you like to jump in here and just share with us your perspectives on these practical challenges?
Yeah, Ricardo, a lot of people forget that trustees are the decision makers of a trust. And that we can see that underestimated and not well understood when we look at when the estate planning takes place. We have to put together a trust deed. Often that is just a vanilla type of a document that somebody get off a shelf. It is not tailored around family circumstances. People don't think about what happens, after I'm no longer around. So a lot of thinking has to go into the planning stage and what ends up in your trust deed. Because trustees are decision makers, we see a lot of abuse happening in terms of follow-up trustees, the number of trustees, the majority decision. We see a lot of abuse around that. So one really has to think carefully about your family circumstances and then plan ahead, not just during your lifetime. And often we see, while the estate planner is still alive and he's hopefully one of the trustees, things still go okay. Yeah. But the moment they fall away, the wheels just come off. So the trust deed is a critical document to make sure that there's no abuse in future, and especially as far as the follow-up trustees are concerned. And then last year when we did that generational wealth transfer, just brings to mind again how important it is to understand different generations, because people think differently. Different asset classes are important to different generations. So the trust, how that's structured and how trustees over generation are going to deal with these assets has to be well understood and best you can plan forward.
That's a very interesting point that you raised, Fia. So it's going to Mark's comment about understanding who you're working with, but it's also looking ahead in terms of actually understanding who will be the future trustees and how will that trust be managed. Yeah, thank you. Richard, your experiences when it comes to, I guess, the practical challenges around trust relationships.
Design-wise, I want to bring back to the trust deed. And I think before one takes on the responsibility as a trustee, you would have to look at the composition of the trustees. Often people abuse the fact that mother and father are trustees and, make the minimum number of trustees 3, and then expect, as Richard alluded to, a puppet trustee who would just basically accept instructions from the estate planner. And often, together with the number of trustees goes the majority rule that people use in the trust deeds. The decisions can be made by the majority. Okay. And families typically interpret that as we can ignore the minority trustee. So we can make decisions, as long as we have the majority, as part of a decision. So when you look at the Lefranti case, which is a very good example of what we mean by joint ownership, joint control of trust assets, the court made it very clear there's a specific process to follow. You cannot just rely on the majority rule to make a decision. There's a process. In other words, every trustee has to be informed that there's a decision to be made or a meeting to be had. Secondly, every trustee must be given an opportunity to attend that meeting. And in today's world, it's very easy to attend meetings. Then all the trustees deliberate the issue at hand, and then they go over to voting. So the court set out a very nice step-by-step basis in terms of how decisions are being reached. And certainly, you can't rely on a mechanism in a trustee to ignore or outvote a minority. So I think that court case clearly illustrates, that all the trustees have to be involved, have to be included in a decision, and it's only when it goes over to voting, which means that person has to be present, then you can be outvoted.
That's right. Yeah, and I think there will always be these contentious decisions that need to be made, and that's the nature of a trust. There will be decisions to be made, and so it's important to reflect on the fact that actually there must be this process that you described here in terms of reaching agreement as trustees. If we just shift the conversation now to the administration responsibility of trustees, I think it's fair to say that administration is not as straightforward as one would think. I think broadly, when we talk administration of a trust, it encompasses holding meetings, very, very clearly around taking decisions on the trust assets, and then recording those decisions in resolutions. And again, then obviously preparing statements of financial position, having an asset register, and making the necessary tax disclosures to SARS, and everything else in between. So if we put that into perspective, I guess it's likely that there will be instances where administration may go wrong. I'd like to, if you can have a confession from around the table. In your experience, has that happened? And what did it look like when it went wrong? And what did you learn from that experience? Fia, can I start with you?
Yes, two main things stand out for me. First of all, it is the type of people we put in the box of a trustee.
Okay.
Huge ignorance around that. So the mother, the father, sometimes the children come on as trustees. They've never been informed what's expected of them. They're never told to read the trust deed, which is your constitutive charter of the trust.
Okay.
Most trustees don't know that you even have to open a bank account, have to register for tax, that you have to submit tax returns. So I think that is probably the cause of most of the issues. I don't think trusts are difficult to administer. There's a couple of basics that you have to follow. And as long as you stick to the basics, then that should be fine. That, however, when one comes to, asset types in a trust and, administration around that obviously creates complexity. But as far as administration, it is really not that difficult.
Exactly. Thank you, Fia. Mark?
Yeah, Ricardo, and I'm going to use quite a specific example because I think it shows some of the challenges that one can be faced with. And, my experience is that the problems often only arise quite long after the event. So it's sometimes difficult to remember all the nuances around the decision that was made, despite having minutes and things like that. And, one such event was trust that I was involved with, provided for the benefit of the surviving spouse and children. And the wording of the trust was in such a way to provide for the spouse to enjoy a standard of living similar to that which she had become accustomed to.
Okay.
Now, that is not a mathematical type exercise because, your standard of living can be quite different to mine. And we both think that we're living to a high standard. And it sadly ended up in legal action between beneficiaries, the mother in this case, and some of her children. And I guess as an independent trustee, at a point in time, fairly soon after in what in my view was excessive spending, one needs to get back to the basics, and that is what is our responsibility as a trustee, and that is to ensure that the beneficiaries, in this case not only the surviving spouse but the children, also derive a benefit over a period of time. And the way that the mother was spending or requesting funds was just not sustainable, and as a result, we needed to pull in the allowances that were granted to her, and that's always a challenge. You know, when somebody is accustomed to overseas trips on regularly, and some fairly fancy cars, to ensure that the next generation of beneficiaries do in fact benefit, there's some tough decisions that need to be made. And that's why we're there generally.
Absolutely, you're right. And I think you've painted a very, I think, a real scenario, Mark. It's that balancing act between what's best for all the beneficiaries, and that's the role of the trustee in terms of making appropriate decisions. And so I think if I can just pick up on one comment that you said, and I'd like to hear further from you, in that instance where it was challenged in court in terms of actually what was appropriate for the standard of living, or just looking at the decisions made by trustees, what did the court rely on in terms of evidence? When you say, obviously this is post the event, quite long afterwards.
Ricardo, it was a really interesting outcome because the judge, who was a very senior judge in that case, just appealed to the family. And he said, this is possibly one of the worst situations that can arise. And he asked the counsel for each of the family members involved to go back and try and resolve it, which is in fact what they were able to do over a period of time. So in that case, there wasn't a legal outcome in terms of a judge prescribing what the outcome should be. He really just appealed to the senses of the family. And thankfully, we were able to get an outcome that seemed to satisfy all.
Okay. That is an interesting approach to be taken, but I guess a very practical one. Thanks for sharing that, Mark. Richard, would you like to share your experience when administration goes wrong?
Yes, I think just to pick up again just on what Mark is saying, I have had the experience of a similar thing where a founder tried or did provide for his spouse, but he did it differently in that he laid down the numbers. In other words, my wife is accustomed to a certain standard of living, and that would require X thousand rand per month now. And she's accustomed to having a motor car of this class every third year, and these to be increased by the consumer price index each year, etc., etc. So he was laying down some sort of formula, and that actually worked for many years.
And that's a great reflection, because that really then helps in terms of administering the trust for the benefit of beneficiaries, having clarity on what the objective is.
Correct.
That's a great example. Thank you, Richard.
And the other side of that as well is, if possible, if one is advised, if you as a trustee, or if you're fortunate enough to be asked for your advice while this is being set up, that you ensure that the family, the founder, is clear in his mind of what his objectives are, because each trust is different. This trust that I've got now, that I'm a trustee of, is this meant to last in perpetuity, which is its structure, or did the founder form it for the benefit up to the third generation? So it's got a limited life. And understand, in other words, the capital you're using, have you got to protect that capital? Have you got to distribute that capital? You must be very careful that we do work within the framework of the trust deed. So that's just linked to what Mark was saying. But from our side, the type of trust that I have problems with, the only type of, fortunately, that I had problems with is the dormant, inverted commas, dormant trust. And it's the type of trust that lands on your lap through life, someone comes and says, will you be a trustee? And you're happy to be a trustee for that particular person. You've evaluated the person. But the only thing the trust owns is a couple of properties, and nothing happens for 25 years. When I say nothing happens, I mean nothing happens. Doesn't get sold, doesn't get purchased, there's no rent, and no administration gets done. There's the risk. People don't understand. It's a trust. You've got to conduct it. You've got responsibilities from a trust point of view, and that's a breakdown in administration, and that's very dangerous.
Richard, and that's a very powerful example and scenario that you've shared. And the reality is that there is no such thing as a dormant trust.
No.
A trust is alive from the time that the letters of authority are issued. And that misconception is dangerous in terms of that lack of energy and effort putting into administering a trust because it's appeared to be inactive. So yeah, thank you for sharing that. And I think that is a real administrative challenge for trustees. I think we could carry on unpacking a lot more war stories and I guess challenges that each of you have encountered as independent trustees. But I'd like to close out our conversation today. And if I can ask you just to go around and share with us that one golden nugget for the trustees listening in. And in terms of what's that one piece of advice that you would want to share with those trustees when it comes to trust administration? Mark, we'll start with you.
Yeah. Ricardo, I'm actually going to split mine into two, if you don't mind. The first is, often we become trustees once the trust has already been formed and it's in place, and there's precious little that one can contribute to the structure of that trust. And I guess my advice here is really just to have a close look at your fellow trustees, how they're involved, are they beneficiaries? It's pretty much like accepting a directorship in a company. Are you comfortable with those that you will be working with? And particularly, as I say, even more so when those fellow trustees are beneficiaries. And then the second part of my answer is really in connection with those that you have input into the structure of the trust, and is not to try and expedite the creation of a trust just for the sake of getting it done. It's really to apply your mind, use all the experience that you might have had over your years as being a trustee in ensuring that you don't make those mistakes which some of us have spoken about today. So
it's lovely.
Yeah, that's just my bit.
Yeah, thank you, Mark. It's very powerful. Not to rush into it.
Yeah.
Wise words. Richard, what would your golden nuggets be?
A few words. Be a communicator. Communicate with your fellow trustees. Communicate with the family, especially adult children that have not been involved in the trust. Be informed and knowledgeable. Be transparent and be decisive.
Thank you, Richard. I think those would ring true as really, I think, good pearls of wisdom to take away. Thank you. Then Fia, closing final word from you.
Ricardo, I think I sound like a gramophone this morning. If there's one thing I can always refer people back to, is always go and read your trust deed. You cannot act outside of your trust deed. Secondly, when you have decided to act as a trustee, always remember that you were asked on the J417 when you signed up to be a trustee with a master. You said you have to say yes or no to the following. You have knowledge and understand the law of trust, so no excuse to claim ignorance. You are aware of your fiduciary duties, and you will always exercise direct personal control to maintain accurate trust records. So if you have answered yes, I think you better do so. And if you are not willing to do so and not even aware that you should do so, one should rather step down as a trustee.
Yeah, absolutely. I think spot on. And the simplicity of your golden nugget there, Fia, is so rings true, because a trust deed is very seldom read, let alone the J417. Thank you, Fia, Richard, and Mark. This has been a fascinating conversation. Thank you for making time to be in conversation with BDO and talking trusts. The practical experiences you have shared are valuable and I think certainly will resonate with a number of trustees listening in. The next episode in Talking Trust will be on understanding the real purpose of a trust. How do you as a trustee get to understand the trust objective and what the founder really intended? And what happens when the founder passes? How do you ensure that the trust objective will continue to be met? Until then, stay well, and thank you for listening to Talking Trusts. This is a Frankly Speaking podcast series brought to you by BDO South Africa. If you need help in simplifying the burden of trust administration, or if you have any questions relating to trusts and wealth management, reach out to BDO Wealth Advisors. Email trusts@bdo.co.za.